dedicated to empowering you with information
to make positive choices
and be advocates for your overall well-being.
Welcome to The Health View. Welcome to The Health View. I'm Yvonne Dunetz, and today we're going to be talking about advanced directives, wills and trusts, and what information you really need to know. My guests from the Morneau Law Offices are attorney Sarah Paris and paralegal Abigail Reville. Welcome.
Thanks so much for having us.
We're so pleased to be here.
Well, I'm pleased to have you. And let's talk about what is the most important information that people need to know and have.
Well, that's a really good question. Whenever I talk to people when they come in to see me, I always like to give them an overview of all the documents that we do that they need in order to have an entire estate plan. And that word estate plan, I think, throws people off. They think that it means something where they have this big estate and they have to have money. An estate plan encompasses all your legal documents that take care of a number of things, including the advanced directives that you mentioned in your intro and wills and trusts. And so I give the overview of you need your advanced directives. And so when I talk to clients about advanced directives, there's three main advanced directives that we do. We do a healthcare power of attorney, we do a living will, and we do a general durable power of attorney, and that's for financial matters. And then the other part of that on the other side that is documents that we call them dispositive provisions, but they're the documents that are going to get your assets to your beneficiaries. So those are your wills and your trusts. So I always recommend that you have all your advanced directives and that you have a will and a revocable trust in order to have the complete set of documents that are going to take care of all your estate planning needs during your lifetime. And again, estate planning is sort of a misnomer in that those advanced directives, a healthcare power of attorney isn't something that somebody who is rich needs. It's something that everybody needs in order to designate who they want to speak for them when they cannot.
And when they cannot, if they don't have somebody designated to do that, in the state of New Hampshire and other states throughout the country, if you do not have it, what happens related to guardianship and someone that's a stranger that now takes over?
Yeah, that's a very good question as well, Yvonne. Now, as far as that goes, if someone's lacking, for example, a healthcare power of attorney, they have not named anyone to make medical decisions for them. So what that means is, for example, if they're in a car accident, there's no one that has the ability to, let a doctor know what medication they might be able to have and things of that nature. Now, that would require someone going to the probate court and seeking guardianship over them in order to make those decisions for them. So it's very important. At a minimum, we tell people, even if you don't necessarily want to do a will or a trust, at least have the advanced directives, at least have the financial power of attorney, allowing someone to make financial decisions for you, the healthcare power of attorney, allowing someone to make those medical decisions for you, and a living will that is kind of a sister document to the healthcare power of attorney that talks specifically to the medically administered hydration and nutrition on a person's deathbed.
So advanced directives really speak to if you're not able to communicate
Correct.
What your wishes are.
For the most part, that's true. And when we talk about advanced directives, it's not just something for even middle-aged people. I have people that come to me when their children are getting out of high school because that right as a parent to be able to access your children's health and be able to make decisions for them, especially if they're not able, it ends when they turn 18. Yeah. And so if that child doesn't have documents in place, then these parents are stuck going to court to get that guardianship. Mm-hmm. And if they had the healthcare power of attorney in place, they wouldn't have to go through that step. And it's very it's a hard process when you're already dealing with a difficult time. So advanced directives and healthcare powers of attorney are not just healthcare power of attorney. As Abby said, you want more than just your healthcare power of attorney because if you're over 18, you probably have a checking account. And just being able to access that checking account, nobody's going to have access to that unless you have a financial power of attorney that's there. And again, you'd have to go to court to get a guardianship without that financial power of attorney in order to be able to assist somebody to pay their bills and take care of them in a time of need.
So Is it difficult to do? What do people need to do in order to start that process? Because I would think it'd be important for their physicians and their providers to know their wishes.
Right. So, I mean, we start the process just by having people come in and have a conversation. We're sitting down, we're having a consultation, we're talking to people about these documents, about how they're helpful, and about how to use them. So essentially, once the documents are drafted, we've had that meeting with people, the documents are drafted, the client would review the drafts, we'd finalize them, they'd come in and sign. But in particular, with regard to the healthcare power of attorney, we'll send people out the door with their original, with a copy, and then we'll also email them the digital copy, because we tell people that it's very important that you give one copy to your primary care physician. You give a copy to the hospital you would use most. And also, for example, if you're traveling, no one would know, if you're in another state and something, heaven forbid, were to happen, they wouldn't know what to do. So we tell people to take a copy with you in your suitcase, or if you maybe in your pocketbook or something like that, where it's easily accessed, so people know your intentions. Otherwise, they're left scrambling.
Right. And I mean, the process, we make it as simple as possible, because we know that people dread this. And I usually congratulate somebody who makes it to my office, because so many people put this off because it's overwhelming to them. And so, one of my goals when I meet with a client is to make it as approachable as possible, because it's really straightforward. The healthcare power of attorney is going to ask you a bunch of questions. You're just going to answer what your preference is. You have to deal with some difficult questions in that document, but you do it, you get through it, and then you have this peace of mind that you have that document there that's going to say, this is the person that is going to make my medical decision for me, not somebody that got picked by the state because I didn't leave anybody there and I didn't have anybody picked. So this is something that is a sigh of relief when everybody is done with it. And I always, again, congratulate them on making it through the process, and really, we just get it done so that at the end you have this peace of mind in a little binder that we're going to give you and send you home and say, here it is. And we say, it's important, make sure that the people that you pick as agents know that they're agents, and that they know where those documents are, those originals, so that they're there when you need them.
Very good. And hospitals also have information related to that too, to help
Absolutely.
people along, and online too. If you look up, advanced directives, you can get some information to at least start the process so that you're not fearful about it. Wills and trusts. What are the differences between a will and a trust?
That is a great question. So the difference between a simple will, because there's more than one type of will. A simple will and a trust is the process by which a person is going to have to go through to get the assets that are set out for the people you intended them for. So when people think of a will, they think about, I want X, Y, and Z to go to, my daughter, my son. And you would put those indications in a simple will if that's all you were going to get. But what I advise people and what I go through with them is, when you do a simple will, that is going to be subject to the probate process. You are going to have to go through the court process.
Why?
And because it is a legal document that requires that. So in the document, you name an executor who's supposed to be in charge of administering your estate. But actually, what most people don't understand is that executor name that you put in there is just a nomination. It doesn't mean anything until a court says they have a certificate of appointment. A court is required to appoint an executor. So it doesn't just happen on its own. It has to happen through the probate process. And we always explain to people what that process is so they understand this is the process that you're going to go through if you have just a will.
And what is that process?
So Abby's really the person who is great for that process, because she does the paperwork really for this. When we do wills, she starts the process. So Abby, why don't you tell what the first step is?
Well, I mean, as far as the probate process goes, Yvonne, it can be lengthy, it can be costly, and it can be very daunting for the average person. So you start with this will. You have this document that names, your sister as the person who's going to handle your affairs, who's going to distribute your assets to your loved ones and what have you. what we generally do is we draft a petition for estate administration. That's the document that you submit to the court, and you're asking the court to be appointed as the administrator or executor of your sister's estate. Now, that just doesn't happen overnight. We submit that document. There's a filing fee that goes along with it, and it can take anywhere from a few weeks to sometimes over a month to be appointed. Never mind, then the process of administering the person's assets. First we collect person's assets, we pay their debts, but you have to find out what their assets are. Sometimes you don't even know, and you can't just go into someone's bank account without being appointed. You have to have that authorization. There's a minimum of 6 months that an estate has to be open in the state of New Hampshire. It's called a creditor window, and that allows creditors to be able to file a claim against your estate. So that's the minimum amount of time an estate has to be open. So during that whole 6-month process, you're going through the process of administering the assets and paying the bills and things of that nature. So, that's if you have just a simple will. That's why, as Sarah was saying, we suggest oftentimes that people get what's known as a pour-over will that's coupled with a trust.
Right.
And those two documents work together to avoid the probate process.
And how do they work together?
So the way it works is with a pour-over will, the reason we call it a pour-over will is that...
Pour over.
Pour over, exactly. And it's all it's doing is in the will, instead of naming who you want to get your assets, like, my 2 kids split everything, you're going to say everything I own goes into my trust. That will is there just to get your assets into your trust. The pour-over will is going to pour the asset that you forgot to put into your trust into it. And that way the trust... Yes. Well, it's not automatic. It's got to go through that probate process. Mm-hmm. So, but what's great about a pour-over will is it is eligible for a waiver of administration. So it's going to be subject to only the 6-month window instead of having to go the whole year, which is, it's nicer the less amount of time you spend in court, the better. Not that you have to go to court, but the less amount of time that you have to deal with court filings and dealing with their deadlines and their forms is what you want to do. And that's why we often, whenever somebody's asking me what I recommend, I'm going to recommend to them a pour-over will with a trust, because the way it works is the trust is really what's supposed to control. This is the important part of your estate plan. This is where you're going to say where everything goes. But you're also going to, the way that it works, the way that you avoid the probate process with a trust is because that trust is going to have it's going to be like its own legal entity. And so instead of having something in your name, so Yvonne, this checking account's in your name, it's going to be Yvonne as trustee of the Yvonne Revocable Trust of 2019. And you're going to now no longer have that asset in your legal name. If you have an asset in just your legal name, it's going to have to go through the probate process. Mm-hmm. If it's in the trust, it doesn't go through the probate process. The trust rules how it is going to be administered. And so the trust is basically going to avoid that probate process by making sure nothing is in just your legal name alone. It's in your trust, which is like a metaphorical box for your assets. So when somebody hires me to do a trust, if they own a home, the first thing we do is we're going to deed that home into the trust. Mm-hmm. Then we do something called a deed of personal property, which says I, so-and-so, deed all my personal property into my trust. And that is going to get all your untitled personal property into your trust. And then Abby drafts a wonderful instructional letter on how to get each asset other than that into your trust that, talks about your checking accounts, your cars, mm-hmm. any other asset. And not all assets need to go into your trust, just probate assets.
So what are probate assets?
That's a good question. Go ahead.
Now, as far as probate asset, any asset that's going to fall under the probate process is going to be an asset that, 1, is in your name alone. 2, an asset that doesn't have a named beneficiary, or 3, an asset that's not titled in the name of your trust. So The goal of the trust is to fund that trust with all of your assets during your lifetime. You want to put everything that you own into that trust. And any asset that you forget to put in the name of your trust during your lifetime, or that does not have a named beneficiary, such as, a life insurance policy or a retirement account, any asset like that, those are the types of assets that are going to fall under the probate process. So that's why we really do stress to our clients, maybe almost to a fault, how often we stress to our clients about how important it is to fund your trust. It's now you have a trust. What do you do next? You fund it. You put your stuff in there.
What's the difference between a revocable trust and an irrevocable trust?
Very good question. So what we do at Morneau Law is revocable trusts. They are not going to change how you own an asset. The asset is still yours, and you're still going to do with it what you normally do. You still have the same control over it that you always had. It's just the difference is going to be in the title, in the name. On the other hand, if you have an irrevocable trust, that is going to take the asset, that whatever it is you're putting into the trust, that asset's no longer going to be yours. It's going to be held in the trust for the benefit of the beneficiaries. And an irrevocable trust is oftentimes used to avoid a Medicaid from taking your assets when you go into nursing home care. So there are some people who will put a primary residence into an irrevocable trust in the hopes that if they do it in a certain amount of time within, a 5-year look-back period for Medicaid, that it will avoid that asset being taken to pay for the nursing home costs of the individuals who originally owned that house. So they are very different. They have completely different purposes. The purpose of a revocable trust for most people is going to be to avoid the probate process. There's also other reasons to have a revocable trust. Sometimes we call it dead hand control. It's when we have a trust that's going to outline how your beneficiaries are going to be able to receive their assets. And you might say, you know what, Junior is not very good with money. I don't want them to get $1 million right off the bat. I want them to get, a percentage at this age and a percentage at this age. And so you can kind of hold on to it. Even though you're gone, it's still being held for the benefit of your child or whoever it is you're looking to protect.
Contingency. It's putting a contingency on that gift.
Exactly. So that's another reason that you might want a revocable trust. And then the irrevocable trust's purpose, a lot of times, is to protect an asset. So they're very different.
Example.
The asset, like for instance, with the Medicaid, most people do put like a beach house. If they have a great family house that they want to keep in the family, they might put it in an irrevocable trust. We don't recommend that you put anything in an irrevocable trust unless you have enough money in your care to take care of yourself through a nursing home care for 5 years so that you make it through that look-back period. Because you want to make sure that there isn't going to be a disqualifying transfer with Medicaid. So it also, if you need an irrevocable trust, may depend on your asset level as well. So it's very dependent on your circumstances, and that's really what they're used for.
What are the most common mistakes people make in this whole estate planning process?
I would have to say not doing it.
Not doing it.
To be honest with you, I can't tell you how many times, Yvonne, we have clients come in and they literally will be breathing a sigh of relief when they leave because, like Sarah was saying, they dread doing it. And it's this, oh my gosh, we have to go to a law firm. Oh my gosh,
it's overwhelming.
Maybe pay a little bit of money, whatever the case may be.
Does it cost a lot?
It depends on the plan that you get,
depends.
really. It really does. It's a very case-by-case basis. It's tailored to each individual. But in the absence of these estate planning documents, what you're doing is really leaving kind of a mess for your kids, your family, your loved ones, who are otherwise most likely grieving. If you've passed, they're going to be busy grieving. They don't want to have to be worrying about, what do we do next? Yeah. So that's kind of where we come in. We kind of try to help people through that process. We do estate administration too, which is the other end of estate planning, after the fact, as we had mentioned.
Right.
But I think that...
Explain that, please. Estate administration. What do you do related to that?
That's the probate process.
That's the probate process. Yep. That's what a will has to go through. If you have a simple will, we're going to have to do estate administration, and that's where Abby starts with filing that petition for estate administration with the court to open the case. And during that period of time when that's happening, I think I wanted to mention, the executor has no power during that time to access the financial assets of the person who's passed.
Right,
So
between the filing and the appointment.
Right.
Yeah.
So if there's a mortgage payment due in the meantime, then in order to, make sure that the house doesn't go into foreclosure, I've seen some people say, oh no, and I'm going to pay it out of my pocket. And there's better ways to avoid that, and a trust can help to avoid that process.
So that automatically pushes it over, let's say the house and the mortgage type of example, into the trust where the executor is in there and then immediately gets access?
So that's if you have a trust. Yeah,
Right.
If you have a trust, you're going to have the ability. The great thing about a trust is when you name your fiduciary, in a will, the fiduciary is an executor. In a trust, the fiduciary is the successor trustee. Same job, different name. I mean,
But doesn't have to go through probate
that's
in order
right.
to do what
The
needs
trust
to be
is
done.
going to allow the successor trustee is going to jump into their position and have the authority and power to do what they need to
Right
do
away.
right away upon the incapacity or death of the person, of the surviving trustee.
So is it behoovable for everybody to put everything into the trust?
Well, that's the difference between those probate and non-probate assets. So any probate asset, you're going to want to put it into your trust. So probate assets include things like your car. Your house is somewhat of a probate asset. That's a sticky legal area with houses, because technically, if you get into the nitty-gritty of the law, real estate vests in the heirs upon the passing, but it's subject to divestment by the estate if there's a mortgage payment. So very complicated. So I just say your house is a probate asset. Think of it that way.
Okay. What other assets?
Your car, your house, your checking account,
Anything without a
anything
named
without a
beneficiary.
named beneficiary. So the things that I tell people that are not necessarily going to need to go into your trust are things like your retirement plan. We don't advise people often to put their retirement plans into trust because there's a tax implication to doing that. Whereas
so where do they put them? Leave them alone?
they leave them with beneficiaries. You want to put a warm body as a beneficiary to a retirement plan because they're going to have the best tax benefit from doing it that way.
Like a spouse or children.
Spouse or children. So usually somebody names their spouse as the first beneficiary and then their children as the contingent. And that way it goes directly. It doesn't require the probate process. Life insurance also. Life insurance can go either way. Life insurance is not a probate asset if there's a beneficiary named. But in the situation where we talk again about dead hand control, the life insurance might be for a large amount that you don't want a child to get all at once. So you say, I want the life insurance to be going into the trust, even though it doesn't necessarily have to, so that the trust gets to say, you don't get that money until this certain event or this certain time. And that way, the person who started that trust has the ability to kind of keep control over the money a little bit longer than their life.
So what is the most important information that you would like people to know about what they need to do and how they need to go about preparing the information to get it ready to take the action that they need to make?
I'd say come in and see me right away. We do free consults. So, I mean, you have nothing to lose by coming in and having the conversation where I basically kind of go over what we've just talked about. But I go into more detail and a little more depth on each specific thing. And then I let you know, here's the process, here's how we do it. It's really a lot simpler than people think. And it's on us. I mean, we're the ones that are going to do the work and we're going to explain everything to you. That's our job.
And is that the same with every law office throughout the country?
It's definitely going to be different for each law office. I mean, some people do not do free consults. Our free consults are for initial estate plans, but we do, if somebody's got an existing estate plan, we're going to be reviewing that at an hourly rate. So that's our own personal policy, but every law firm has a different policy, especially with regard to fees. And how they do the process is definitely going to be different. I think that we excel at meeting clients' needs, quickly and being responsive and making them comfortable with what they're signing and what they're doing. Because, as I always say to them, when we do most of these documents, they're flat fees, so there's not an hourly clock running that people think of when they think of lawyers. So I always say, please ask your questions, because I want you to understand everything. There's no consequence to, continually coming back and saying, well, what about this or what about that? Right. And that way I know that when they're done, they know what they have and their legal documents are taken care of. I think Abby is right. One of the biggest mistakes that people make is not doing it, and then they leave a mess behind for their loved ones. And another big mistake is to try and do it yourself online with LegalZoom. That's
why. What happens when
because
you do that?
A lot of people don't understand that the document may or may not be fine, may or may not meet your state's criteria, but a lot of problems come into play when people try to execute the documents properly, and there's a process to executing a document.
Every state has a different.
And every state has a different process. So, when we get a will from a different state, we actually have to get it.
We have to look up that state's law, make sure that it was executed according to that state's law.
And then do an affidavit to the court to make sure that it's been done properly. And execution is where a lot of people mess up with when they try to do it on their own.
And that's an interesting point in the respect that some people may decide to move from the state that they have executed all of their documents.
Right.
What do they need to do if they move? And they've done all the things that you recommend they do. And now they're going to leave the state that they're living in. Once they get to the place that they're moving to, what do they need to do?
Well, we do have clients that come to us and say, hey, I want to get my documents done now, but we will be maybe moving in several months. The goal of the documents is that they travel with you.
Yes.
Each state is supposed to honor your documents. I will note that each state does have a little bit of a different, law with regard to the particular drafting of the documents, but when you do your documents in one state, they follow you.
Yes.
Yeah.
So you don't have to worry.
No, I do tell people if you're going to a new state, especially if we've done a trust, I say, well, you can consult with an estate planning attorney in that state, see if there's anything that needs to be done to, update your documents. But most states have reciprocity so that they can do what we do here in New Hampshire, which is we have a statute that says if you have a will from another state, just make sure it's complied with their methods, and then we will honor that will.
Right.
And most states have some statute like that to make sure that their documents are honored. And our trusts say, these are New Hampshire trusts and they are ruled by this law. We have great laws in New Hampshire for trusts, so I say there's not likely going to be a reason to change that, but always check.
And for people to learn more, I believe on your website you have some informational literature that people can access at no charge. What is your website?
Our website's www.morneaulaw.com, and I will tell you, Yvonne, it's a wealth of information. We have blogs that we've written, we have links to different things, we have so much information for people. So if they're looking for extra information, not only can they reach out and call us, they can check our website. They can feel free to peruse and look through it. And obviously, if they have any questions, give us a call.
Absolutely.
That's excellent. Well, we appreciate everything that you do. This has been a very informative
Thank you.
show. So thank you so much.
Thanks for having us.
Until next time.